what's in the main data.
Now, they mentioned that affidavit in opposition file
I have filed already in
Where?
in
in the main case.
the
Yes, we have filed in the main case.
only day before yesterday.
You don't want to file reply?
No, in the. Your worship, today IA is listed, 24 IA, there's one IA, but in the main I filed my affidavit.
What is the IA for?
IA is, your worship, but here in this case, your worship, the petitioner, he has implicated Putu Mandal and also village council as respondent number 1. So the IA has been filed by the village council for deleting for deletion as party respondent.
But this is IA is for removing the name. And the interim order is passed in the IA. Why? What interim order?
In the main case,
Okay. So there's a stay order.
Right.
Put it in the main case, huh? Main case, Ms. So-and-so appearing on behalf of the petitioner submits that the respondent numbers 1 and 2 have filed an affidavit in opposition on 23/3/2026, and the petitioner would requires 3 weeks time for the for filing the affidavit in reply. Who appears for the others? State won't file any affidavit. Mr. Longkumar, the learned counsel appearing on behalf of the respondent number 3, 4, 5, and 6 submits that the petitioner, the respondents would also like to file an affidavit in opposition. Taking into account the above, list this matter again on 11th of May 2026. The affidavit in opposition reply be filed by the petitioners on or before 4th of May 2026. Mr. Longkumar, the official respondents shall bring on record their stand on or before 29th of April 2026. Liberty given to the petitioner to file reply on or before the next date. The interim order passed earlier shall continue till the next date. And why you want yourself to be struck out?
No, I am there, because I have issued a report. I am there.
Then why this IA for?
The IA has been filed by the village council. There's also filed a big of the big things.
Why have you filed this?
For the division, because the agent order was issued by me, not by the division.
So they say that they have nothing to do.
That matter existed bigger.
Then why are these IA? The village council has no business. But do you want to lose your?
We were under the village council, and standing on behalf of our family.
The council, IA list the matter again on 11th of May 2026.
For admission, item number 7.
Yes, Mr. Khera.
My lord, we have filed an affidavit. My lord had directed us, my lord. My lord,
Have you acquired the right of way over the petitioner's land?
my lord, there was no question or no situation ever arose for us to acquire any right of way over the land of the petitioner. My lord may come to page 29. For a better, my lord, we have tried to, as far as possible, tried to show the actual ground reality.
Okay.
Page 29, annexure 2, my lord.
Ah,
My lord will see the legacy of my tower.
ah.
Now, my lord, when this tower was erected, out of the 4 lakhs, 3 lakhs were in the land of one particular petitioner. One particular landowner, and the 1 lakh was in the another landowner. So they have already been compensated. Now, my lord will see, post this where we have written nearest cutting edge. My lord, we have endeavored to have a very clear photo given, my lord, if my lord can see.
Hmm.
My lord, from there is a gorge. So the land of the petitioner is below in that gorge. What he has done, my lord, will see the subsequent photograph at page 30, my lord.
Hmm.
My lord,
Okay.
from there they have come, my lord, and that has affected the integrity of the tower on top, my lord.
Oh, he's doing down below.
My lord, it's several feet below, my lord. But from here it has come, and my lord, the subsequent page 31, my lord,
Hmm.
my lord would see the query. It stretches, my lord, for a very long area. We have no issues in the areas ahead. But my lord, the where we have written the nearest cutting edge from tower like C, my lord.
So you say that if this portion is done, there's a big problem.
My lord, uh, uh, photos are my lord, page 29 and 30, my lord. It's very clearly seen. We have given the area also that the cutting edge has come to all 13 meters from my tower like C.
Hmm. So why don't you take the right of way?
My lord, this tower cannot be placed over here anymore, my lord.
You are
And
moving out.
my lord, we are moving out. We have done inspection also. However, in the realignment, my lord, the new landowner from where it will go, he is creating objections, my lord. We have annexed that also.
So you exercise your powers under that act.
My lord, we are in the talks with the district administration, my lord, under 16(1) of the same act, my lord. If we are being obstructed, the district administration will have to step in to ensure that we are being allowed to exercise our powers, my lord. So we are on the process of it, and it should be done. That is, we have taken a very clear stand that we are going to shift the tower, my lord.
Okay. Now, what is the impugn order, Mr.?
Uh,
Let's see the impugn order of the district commissioner. Where is it?
My lord would find it at Annexure 6, page 66
Mr.
to
Counsel,
69.
where is the impugn order? Okay, here. Got it, page 67. Now, Mr. Counsel, the thing is like this. We see here the direction is only not to carry out the querying activity just nearby the tower.
Exactly.
You don't carry out for some time.
Lordship,
Yes.
let me have a short submission on this. Lordship, it is an admitted fact from the power grid that my lane is not acquired. That is the first mistake.
Here,
Now it's a private lane, purely private lane. Now what we are saying is that without the following of due process, they cannot stop, they cannot restrain my activities because the concept of installation of this transmission line, we have exercised that during the year started from 11/14, commission on 15. Whereas my activities of during that storm exist prior to that. So that is because that is my profession. And then see, we are saying that, see, they are also saying that, yes, it is not on the right of way. And then when we see the Electricity Act from 23, it clearly says that you have every right for right of way, provided you have to give a proper compensation by following due process law. So on that line, we are saying, and then see, because of this restraining order, we were called for a meeting for 3 occasion. And then in the meeting itself, they have apprised in the meeting there, and the result that they have decided to shift the tower to some other place. Thereby meaning they have they have also admitted that our land is not acquired within their acquired perimeter. So when they are saying that how on what basis, on what legality, there is this legal restraining order from the DC, because this restraining order was made on the complaint made by the power grid. So such legal restraining order on the private land cannot be continued for such a long time, because for such a in the meeting itself, he have resolved it, he will shift it to some other place.
Mr. Counsel, what
Yes.
you are saying, I understand. There's no quarrel with that.
Yes,
You have a right over the land, it is okay.
yes,
But the fact remains one thing, there is another aspect. How does the DC get the power? DC has no power to exercise this.
Lordship.
DC cannot say that you could do this or do that. That power has to be exercised from somewhere. That
Yes.
don't do it because this is not the land where they have taken the right of way.
Lordship,
So right of way, if it is taken, then the DC has the power.
right, Lordship.
Not the DC doesn't have the power. But the fact remains, whatever may be, if the tower falls down, it will also not be in public interest.
Lordship, Lordship, see, it is an apprehension of the respondent that it may fall. And then the reality, the fact is that
No,
By-
therefore,
by
it
let-
is only mentioned directed to restrain from carrying out the quarrying activities near the tower location till further acts.
Lordship, my lane does not reach even up to that tower line.
They have filed some affidavit. Have a look at it. Have you looked into it?
Lordship, even we have given the photograph,
Hmm.
given the place the photograph. See, that exercise of quarry was being carried out for prior to the concept, as I say repeatedly, concept of the installation of transmission line.
Yes, Mr. Sandam, what do you say about this thing? You
My
don't have the power to do all these things.
My lord, based on the complaint lodged
So
by
what?
Boundary
You don't have
on
the
second
power.
May 2023.
No, you don't have the
restraining
power.
order was issued.
No, my question is, Mr. Sandam, where is your power? You have to exercise the power from somewhere.
Based on the complaint received. from-
No. Complaint is somebody's grievance. My question is, where is your power? Are you the king?
No, my lord.
Who are you to
However,
exercise that power? Stop him from his land.
my lord, however, being the head of the administration.
You cannot. I think we have a constitution. We have a rule of law. You have to show me your source of power to interfere with his right. Otherwise, his rights under 300A is being violated.
Lordship,
The
No.
main respondents are respondent number 6 and 7.
Understood? Whatever may be. He has come against this order.
It
If
was
they are the
resolved-
main respondents, it is okay. But
It was
what
resolved
me,
that-
why are you exercising power? Yes, you can exercise your power under 16 of the Telegraph Act. But once you take the land, not before that, the right of way has to be taken. Once you take it, you can very well take it. But otherwise, where is the power from? He is not touching upon the land where right of way has been taken by them. Yes, we may not interfere for the time being, taking into account that, yes, it is necessary, but you have to work out with them, with Mr. Khera. Isn't it, Mr. Khera? You and the DC has to work out, but you cannot keep this matter pending like this with a restraining order. DC has no business out there.
My lord, as late as my lord, in my affidavit, my lord, at annexure 5, I have, my lord, we have submitted a technical survey report also to the new landowner for the realignment of the route, my lord. And my lord, the new landowner is causing an objection, so we are expediting, my lord. We have, more than anything, we want to shift the tower, fearing the line may collapse.
Also, the learned counsel appearing on behalf of the petitioner, Mr. L.T. Santam, the learned additional advocate general, appears on behalf of the respondent numbers 1 to 5. No? Mr. N. Khera appears for the respondent number 6 and 7. The petitioner herein is aggrieved by the order dated 18/5/2023, by which the petitioner has been stopped from carrying out the quarrying activities nearby the tower of the respondent number 6 and 7. This court, by an order dated 17/3/2026, have granted the liberty to the respondent number 6 and 7 to file an additional affidavit, and in pursuance thereto, an additional affidavit has been filed on
24th, my lord.
25/3/2026. From the said additional affidavit, it is clear that the right of way over the petitioner's land have not been acquired. However, it is mentioned that steps are being taken for the purpose of shifting of the tower, but on account of certain difficulties with the location identified for shifting of the tower, the further steps could not be taken for shifting of the tower. Mr. N. Khera, the counsel appearing on behalf of the respondent number 6 and 7, further submitted that the said respondents are in continuous discussions with the district commissioner, of which, please? Mokok Chung, in that regard. This court also duly heard the learned counsel, learned additional advocate general, on the question of under what authority the district commissioner Mokok Chung have passed the order dated 18/5/2023, inasmuch as such order, if not exercised within the realm of law, without an authority of law, would be in violation of Article 300A of the Constitution. Nothing could be placed before this court as to under what authority the district commissioner had passed the order dated 18/5/2023. This court would have interfered with the order dated 18/5/2023 as it appears to be prima facie not prima facie, as it appears that 18/5/2008, as it prima facie appears to be without authority and jurisdiction.
My lord.
However, taking into account the greater public interest and the statement submitted and the submissions so made by the respondent number 6 and 7 that they are taking steps for shifting of the tower, this court, for the time being, is not interfering with the order dated 18/5/2023. List this matter again on 18th of May 2026. The respondents number 6 and 7, in the meantime, shall take effective steps with the district administration and other authorities so that appropriate steps, so that the tower in question can be shifted. Or in the alternative, may initiate action for under the Indian Telegraph Act 1885 for acquisition of the right of way in respect to the land of the petitioner.
Lordship,
An update in that regard we provided on the next.
Lordship, may kindly keep us time frame.
I've given it, nah? An update to be given on 18/6.
Because Lordship, this restraining order was passed on 2023. Now we are in
Mr.
2023.
Counsel, I know, therefore I'm putting it on 18/5, saying that in the meantime you work out either to shift or to purchase your right of way.
My lord, sorry for correction. Based on the complaint made by the PART-3 on 2nd May 2023, this restraining order was issued.
Understood? Where is the power? I may file a complaint to you, but you have to have the power.
In order to avert
You cannot.
intentionally.
You may do so under the disaster management if you have the power. But you have to show me some power that this is. Therefore, on public interest, I'm not touching it. I said. And I never said that you don't have the jurisdiction. I said prima facie.
Highly obliged, my lord.
For admission, item number 8.
May it please your lordship.
Yes.
Lord, I am aggrieved by the assessment order and appellate order, your lordship. Your lordship, I am a Naga businessman permanently residing in Dimapur. I am having my business established in Dimapur, Nagaland, and my whole income is derived from within the state of Nagaland, your lordship. I am having bank account, it is also in Dimapur. I am having,
You're referring to section 1026?
yes, your lordship, yes, your lordship. Now, your lordship, I am exempted under 1026 of Income Tax Act. Now, your lordship, I have been assessed for rupees 10 crores and another penalty. And the order passed by the faceless income tax officer, national faceless, and it is being we went for appeal, and it is being what it is called. Our appeal is being dismissed, and after that, I have come before this honorable court.
How do they take care of 1026? Let us see the order.
Yes, your lordship. My lord, at the outset, your lordship, I beg to take your lordship page 39, NHR 1. Schedule type certificate, your lordship.
What did you sell?
Medicine, your lordship. And my medicine shops are at Dimapur and Kohima.
Is in the business of pharmaceutical and running this business under his two proprietorship, namely JK and so and so.
There are 3, your lordship.
Come
And
on.
and I have this page 42 is my that retention certificate medical. All will show that, your lordship, I was running my business at Dimapur, Nagaland.
You are doing business of some
Agri products also, your lordship. Now here your lordship will appreciate that if I take your lordship to page 81, your lordship. A small,
let's come to page 115.
yes, your lordship. Decision and determination. But if your lordship kindly peruse this page 81, this is the assessment order, your lordship, page 81.
Yes.
Page 81. Page 81, it is 14. Then page 90, your lordship. The operative portion is in page 90. This is the assessment order, page 90. Where I beg to take your lordship, this is page 90. Page 90, your lordship. .22, this para number 3, your lordship. In Nagaland, your lordship, we are having a village land. We do not have any revenue patta land, your lordship. And my agriculture income derived out of that has been discarded with the plea that I have not produced Jamabandi, patta and all this. And there is no patwari.
Okay.
And my sale, your lordship, medicine sale, it is being supported by GST return. This is page.
Then what happened? Again, there is a revision under 271A. What order is this? 271A?
271. Penalty, Your Lordship. These are all penalty proceedings.
The penalty proceedings.
Yes, Your Lordship. There are one is assessment order, Your Lordship, and another is appellate.
Mr. Counsel, why didn't you file an appeal in the appellate tribunal?
Tribunal, AIT. Your Lordship, I will not get any benefit. I will not get any relief there, Your Lordship. What this
Why?
income tax authority has passed, the same thing has been repeated because my fundamental right is being violated, Your Lordship.
Why?
Because, Your Lordship, I am a scheduled tribe and I have been given this benefit of income tax 1026, Your Lordship. And Your Lordship, I have taken to
You
your
have filed an appeal. Yes, the appellate order appears to be not proper. But we are not going in. Why should we exercise 226?
Yes, Your Lordship, because it's Nagaland, Your Lordship. I have categorically
Nagaland,
stated
nothing
before Your
different.
Lordship.
Exercise of jurisdiction under 226 is same here, Nagaland, even Ladakh, or even
Yes, Your Lordship.
same.
Yes, Your Lordship. Now,
Why
Your
should
Lordship,
we why should we entertain the instant proceedings?
Your Lordship, since my right, legal right and fundamental right
Legal
is
right, yes, but you didn't approach this court at that point of time when your assessment was made on the 1026. You file an appeal. Go and
yes,
file.
Your Lordship. Yes, Your Lordship.
And thereupon the matter we will decide when the matter comes in reference to us.
Your Lordship, this appeal is a statutory appeal, Your Lordship.
So then,
I've exhausted that appellate forum
then
under section 246.
you have only moved the commissioner of appeals, but you have
Yes,
not
Your Lordship.
that income tax appellate tribunal.
Then, Your Lordship, I've also, my room is also open to come before this honorable court.
Why should we entertain? There's an appellate forum where you will get the benefit. Why should we?
Now, Your Lordship, I have exhausted this
You are
246.
hearing from where, Mr. Counsel?
I am appearing from my council, chamber, Your Lordship. From Gauhati, now I'm in Gauhati, Your Lordship.
Fantastic. The appellate tribunal is in the Gauhati.
Your Lordship,
Very nearby. Why instead of troubling yourself to come to Kohima or
now I am having my permanent setup in Kohima, Your Lordship, as an advocate. Now I am in.
you have gone all the year from here to Kohima to Gauhati to appear through video conferencing.
No, Your Lordship. Actually, Your Lordship, I am suffering from some problem, and I am in medication in Gauhati, Your Lordship. And my son is in Gauhati, so I am boarded there, and from there I have taken the.
Even there. And this is not the case where we should entertain here. Because if we entertain these type of matters out here, it will be, and there will be floodgates. We access normal jurisdiction when the matter comes up to us in reference. Where's the Income Tax Act? Anybody? Has he? No. You see, you have taken the advantage of appearing in this matter out here so that the problem is the court doesn't have even the Income Tax Act.
My lord, then matter may be what it is called transferred to principal city, Your Lordship.
For what?
Because Your Lordship will appreciate that my.
I understand. You have a good case. I'm a bit surprised. You were only to show before them that you are a resident and the income has accrued within the area of the sixth schedule.
Yes, Your Lordship. Yes, Your Lordship.
It's applied. Your tribe is being recognized.
Yes, Your Lordship.
Is it the case if the income had accrued out there? Now, without there being a finding by the assessing officer that your income had accrued somewhere else, how can there be an amount imposed upon you or the exemption not being granted to upon? I understand.
That is why I am before this honorable
Why
court, Your
should we
Lordship.
entertain this type of petition, Mr. Counsel?
My lord, this honorable court has under 226, Your Lordship has ample authority and ample power, Your Lordship, to
Appeal is there. Appeal is there.
appeal statutory appeal.
226 we can, but does it mean that when you have already prepared the Commissioner of Appeals, why should we exercise? We will do it when the time comes.
Statutory appeal I have, Your Lordship. I have exhausted.
You are in Gauhati. You have a good chamber on the backside. We see a chamber unless it's
It is my junior chamber, Your Lordship.
you see your junior has such a big chamber. Therefore, I think you should go and move the yeah. We give you 30 days time. In the meantime, you move there.
Uh,
That
my lord, Your Lordship will appreciate that my sales proceed, everything is recorded sale, Your Lordship. And I have not done any business outside Nagaland. And my land, I am aggrieved that they are not accepting my land documents which has been issued by village authority. They are telling that they require land documents issued by the revenue authority. But in Nagaland, Your Lordship will appreciate that. In Nagaland, land system is quite different from other parts. And we are having village land, and village land, that certificate is being issued by the village authority. And my sale proceed, Your Lordship, pigs, then fish, all these are sold from my khati itself, Your Lordship.
Chalo, do one thing. What is your stand, Mr. Counsel? Your senior is not there. See? I have taken his submission without him.
And Your Lordship will appreciate that till now they have not filed any affidavit in opposition also, Your Lordship.
You don't want to file affidavit?
Lordship, we have taken necessary step and we're waiting for the instruction.
Mr. Counsel, that is the problem here. Getting one tax matter out here, it becomes very difficult. In Gauhati, we have the income tax councils.
Yes, Your Lordship.
We are seeking time.
Yes, Your Lordship. I do not have any objection, Your Lordship. Then I can come physically also can place my case before this honorable court. But I pray that no, tomorrow Your Lordship is going. So otherwise,
Okay. It is seen that no affidavit has been filed on behalf of the respondents.
1 to 5.
1 to 5.
Yes, Your Lordship.
A further opportunity is being sought for by the learned counsel appearing on behalf of the respondents, on behalf of the respondents.
No. R1, respondent 1.
Service is not complete as regards respondent.
Complete, Your Lordship. What are dated 3/3/26? Deemed served. 3/3/26, Your Lordship.
Mr. Goyal, there in the principal, you have a standing counsel of the income tax department in the principal seat. Who are they?
Earlier also, Your Lordship, in cases they have appeared from Gauhati in income tax matter.
You see, you have the central government has no business here. It is
Yes.
the income tax council. This court duly just right there. This court duly takes note of the office note. And it is seen that service have been affected by way of service has been affected upon the respondent numbers 2 to 5. As it appears from the consignment/MO tracking report. This court have been informed that in the Kohima bench of this court, there is no standing counsel appointed by the income tax department. However, in the principal seat of this court, there are 2 standing counsels of the income tax department who have been appointed, one of being Mr. S.C. Kayal and the other S. Setia. Who's taking into account that the presence of the respondent numbers 2 to 5 is essential for the purpose of adjudication of the instant proceedings. This court directs the counsel for the petitioner to serve a copy of the present order along with a copy of the writ petition to Mr. S.C. Kaya, the standing counsel of the Income Tax Department in the principal seat, so that effective steps can be taken. List
My
this
lord.
again on 5th of May 2026.
Much obliged.
Will continue till then.
For admission, item number 9.
Same, your lordship.
Same order.
Same.
You have taken the advantage.
Your lordship have for 2 assessment year, your lordship, 22, 23 and 22, 24.
That you know, that for assessment year, it is required to file 2 writ petitions. That you are aware, but not aware to move the income tax appellate tribunal. Anyway,
My lord, much obliged, your lordship.
For admission, item number 10.
Please, Your Lordship.
Hmm.
Lordship, on behalf of the Ms. Viveka, Government Counsel, that affidavit has been sent for vetting.
it has been submitted that the affidavit on behalf of the state government has been sent for vetting and would be filed within 2 weeks. Taking into account the above, list this matter on 23rd of April 2026. In the meantime, the affidavit be filed on behalf of the state respondents. Full stop. Interim order passed earlier shall continue till then.
For admission, item number 11.
Please. Your Lordship.
Yes.
Lord, we have come in this matter, Lord, confined in a very short point. While determining the compensation, my lord, which was due way back on 2012, that interest was not given.
Huh?
Interest was not given, which was the cause of action arose in the year 2012. And
Then interest was not given
not given.
in the award.
It's the damage compensation. And what happened? It's
What is this damage concept, compensation concept?
The concept is it ought to have been acquired when the main road was, this is called Special Accelerated Road Development Program in the Northeast. It's a scheme made by the central government, but it's the state project. Now, the road which was
SARD, SARDP,
exactly,
NE.
any.
Yes.
Now, what happened, the road was constructed and it ought to have been acquired under the Land Acquisition Act, but they did not do that. They have given a lump sum compensation. It's an exploitation to the poor citizen of the country. As your lordship is aware, that so far the right to property is not there. Nonetheless, 300A contemplates that you are to do certain things in a certain manner in accordance with the law. Now, still, since the land has not been acquired, the land belongs to those poor citizens of the country. Now, so far we are concerned, our land is below the land, the road where road is constructed. Now, while they were constructing, the art cutting and all these things which was piled up on the road during the rainy season street down to those areas, and ultimately it was all permanently areas. Now, the state government has assessed the compensation and came to the finding that we are entitled to get 60 crores and all. Now, while doing that, They assessed in the year below 2016. And the compensation was given was the late 2024 and early 2025. Now, as your lordship is aware, so far compensation is concerned, the owner is not given full compensation unless it is for the delayed period, the interest is not given. So that is the only area where there.
But you have asked for additional compensation in the form of solatium and
No,
interest.
solution will in the sense, your lordship, in that way, if your lordship finds that what the state has done, can they do it in that manner?
Why?
Because Article 300 A says.
The state has been more kind enough to pay you the compensation without you going to the
I'm
court.
not arguing that part. Because we are, the petitioners are satisfied with that amount. But I'm saying the other persons whose land were taken by the state. No, without.
I passed one judgment yesterday on that, day before yesterday on that. You cannot take it like this.
Exactly.
Because it is not the question of the right of the persons affected. It is the question of how the state will have right over the land.
Yes, exactly that.
That
Whether
is
state
another-
has the right now.
But your case is different. You are affected by the constructions being carried out.
Yes.
So they have been given a damage compensation. Go to the civil court to ask
No,
more.
no, we're not for that. We're not saying that it's what we have been under 300 A by taking the recourse to legal position.
You say that you should have been given an additional interest.
Exactly that.
Why should we decide?
No, delayed interest.
Delayed interest, why should we decide? Under what provisions of law? Why should we exercise our equitable jurisdiction?
If your lordship takes.
If you are entitled for interest or not, why should we entertain our
It's
decision?
the Interest Act.
Huh.
Just for you. Interest Act, definition. If your lordship will look at section 3. Statement and exile, if you lordship look at first. Statement of objects and reasons.
When did you get the money?
Late 2024 and early 2020.
And then you filed the petition.
We filed a petition.
In 2025.
December 2020.
And the proviso to section 3?
But the amount of the debt or damages has been repaid before the institution of the proceedings. Interest shall not be allowed into this section for the period of tax repayment.
Why should we apply this for court means tribunal or arbitrator?
Lordship, the compensation generally it includes interest for the delayed period. Now, if I take your lordships to pursue your lordship some of the fiscal decisions. But I just.
Yes, what is your stand, state?
My lord, I'm responding number 5, 6, and 7
Who are you?
as pro forma respondent
Who is to pay the money?
by the Union of India.
Why the Union of India will pay?
The compensation that has been satisfied with them.
Huh?
Because they are the main party because the branches from the Indian.
Compensation is to be paid by Union of India.
Yes, ma'am.
Why?
We are only a supervisory agent.
No. Union of India will have, where is NHRDCL working? You have to, there will be, you see, the thing is like this. You are asking for damage compensation. Union of India is the MOT. MOT does not pay any compensation. They may sanction any compensation, whatever may be, for damages. If it happens on your part, in your case, it would be done either by NHRDCL or it would be done by the contractors. Now, there would be definitely an agreement between the contractors and the NHRDCL. The state union, the people have been very kind enough to make payment of this is too good. Why will the central government pay?
My lord, actually, the state will have to revert that amount from the contractor because it's the fault of the contractor.
No, state has no business.
My lord, but
Who is constructing the road? NHIDCL. Ah.
Yes,
now what contractor?
And
has done-
NHIDCL do not do it on its own. It is done through the contractor. And NHIDCL has an agreement with the contractor that if you do anything, you have to do this. This is what from my experience, I have seen.
In this case, what happened below? It is for the fault of the contractor because there is a marketed area where they should dump on.
Understood. So therefore, it is a fault of the contractor.
Fault of the contractor.
So therefore, the state paying is too much. State should not have paid. You take back the money. You return back.
Now, whether compensation is enough without any interest because you have assessed.
First of all, you are not entitled to compensation from the state. State should not. This is public money.
State did not give me, it's from the central fund.
Understood. Central also is a na? Central government is also a state within the meaning of Article 12
And then it has been settled by the division consolidated.
that you are entitled to.
Yes.
When?
Look at this general-
Then why Order 2, Rule 2 would not apply?
Look, this judgment has to be changed by anybody, it has.
So therefore,
Yes, because-
there nothing is mentioned in the interest. You didn't ask for interest.
In adequate compensation, it has been said that adequate compensation will be paid. Now it has. been-
When was the direction given?
That is, 2023.
Page?
Page 657.
Huh?
657.
657.
You roughly clear, see the operative part.
357.
Yes. Six, operative part. you roughly-
Volume.
Oh,
is 657.
in the operative part, your worship may find 663. Paragraph 5.
Here you see the agreement is made by so and so in the name of so and so representing Matthias. This is an agreement. What is the full form of the agreement? Here the alpha table is used for filling out. There will be definitely the two 657. Okay.
663, pay paragraph 5.
Paragraph.
Paragraph 5.
No disputes on the side of the respondents on the claim that the lands and properties of whose lands are below the road in which in the year so and so. Oh, this is the road from where? Kutsera to Fek.
Fair.
Huh?
Yes,
Kutsera to Fek.
yes.
Okay. Day before yesterday, I
And
passed
you're
the
able
judgment.
to check along
Two parts, sir.
two parts,
Pojuro, Villapuras come. In one
Ah,
side.
this is the two laning.
Yes.
two lanes.
I know.
Also order pertains to that area only, Pet Pojuro area. The order for.
Yesterday, that day I disposed.
Yes, sir.
Further records show that compensation has been paid to the owners of the land situated above which have been.
Pet Pojuro part.
This order is passed in 2023.
Yes, 23.
Part kept chalu actually.
Then the whole exercise should be completed within 6 months. So where is the question of interest?
No, we don't, we are agreed to waive it in 2012. The government has assessed it,
Then it is not the case here.
assessment is done in
The
2016.
court first passed the order that you are entitled to interest, compensation only in 2023.
Adequate compensation, because court is saying, but the assessment of the government, denied it. Assessment was done in the 2016.
So you are saying that there should have been an interest element there.
So,
But how can there be an interest element when it is not your right to get the interest, the compensation accrue only in the year 2023, and that too after 6 months?
Your lordship kindly appreciate one thing. Cause of action arose where in 2012, whenever land is
Mr. Datta, I clearly understand the fact that this construction was made in the year 2012 or 11.
Yes.
At that point of time, rock or whatever maybe fell down and thereby demolished, destroyed your properties.
Yes.
So you have a right to claim compensation. Now, this compensation, they have looked into it only pursuant to the directions passed by this court in 2023.
No, they came to know earlier and they started assessment in 2016.
They make an assessment, but the direction was on the basis of that direction.
No, because we were pressing for that, filed a representation and they made an assessment, they found these are all correct position.
Very well, but then also the direction was passed only on then 2023 to make payment within 6 months. And you got the money.
But then
We can only consider after 6 months, 1 month or 2 months.
But then if we are, say, it is money is what money buys. Now, what
You may say, you may very well have a case. Then look here. What is the compensation given at that point of time in 2012? In the meantime, not giving us the compensation all this while. The value cannot be made then, so therefore we are entitled to some interest. Therefore, the compensation which was paid is not adequate. You may have a case.
that's there.
But therefore, what you are trying to say is that order which has been passed by the learned division bench have not been complied with.
Division bench is saying adequate compensation.
Understood. So
adequate
adequate. So
compensation.
now therefore you are saying as it was done in 2012 and they are making the payment at the rate of 2012. And therefore they should have added the interest on that. And as such, it is not adequate.
Now, your lordship can visualize one thing. Now, 2012, my land, building and all these things have been permanently destroyed. Now, I am required to purchase another land or another building, whatever it is. The question is, if this money I would have got in 2012, I could have purchased in that equivalent amount of land or building, whatever it is. Now, I have been paid in 2024. Now, that value has been reduced to a tremendous extent. I do not have that power to purchase.
No, is it so? Your case is when did they do the determination?
Determination is what is said adequate compensation left it to the wisdom of the appropriate.
Understood. When did they do the determination?
That's 2016 they started because they have.
When did they complete the determination?
If I take your lawsuits to another building, that is in.
No. We go as per this judgment. They completed the determination later on.
Can I please your lordship to repeat? Yes. Volume 3 at page, my lord, 3780.
Kindly come to this paragraph at page 661, page 662. 661. Last paragraph. Last but one
661.
statement. Last but one
The joint
line.
application.
The joint verification was conducted by the officers of the state, aggrieved persons, and members of the local administrative bodies after issuance of proper notification by the deputy commissioner concerned. As per the joint survey, the compensation amount worked out for the landowners between Peck and Futsoro. These are for landowners.
Yes.
Was rupees so and so, and for the landowners between Junavetu and Sakasama Road, it was Iman. However, the state government did not disburse the amount to the landowners on the ground that the state PWD and only the implementing agency and the project is fully funded by the central government, more particularly the Ministry of so and so. Therefore, unless the fund is released by the ministry to it, in the meantime, the contractor asked for escalation of the contract amount. However, the same was refused by the employer. Due to the tussle between the employer and contractor, the execution of the work stopped. While this was going on, the petitioner filed the present writ petition, praying for issuance of appropriate retribution, more particularly the Ministry of so-and-so to pay the compensation as worked out by the state government after the joint survey was conducted. So this is the amount you sought for by filing the writ petition in the year 2019.
Yes.
There is no denial as to the claim of the petitioner that the damages were caused to the land and properties of the landowners whose lands are situated within the administrative jurisdiction of so-and-so. So-and-so. The only plea taken by the state is that this is a project funded by the Ministry of so-and-so. Since there is no dispute and so-and-so, it appears that the problem of paying the compensation to the owners of the land, they have a right
There
to
are
recover
five
adequately for the lands, property, standing plots affected by the construction of the road. And
Since
it
there
is
is
the
no
damage
dispute.
so and so. As such, the state government shall first. Now kindly see page 665. Admittedly, the damage caused to the lands and properties have been already assessed by conducting a joint survey, and even the quantum of compensation amount to be paid has been determined under the leadership and supervision of the deputy commissioner concerned. As such, the state government shall make the first move by submitting a proposal along with the assessment made by the central government ministry concerned, and on receipt of the same, the latter shall initiate the process for allocation of funds and release the same to the state government, who then shall disperse the same through the deputy commissioner of SOYA to the genuine landowner whose lands, properties, and standing, etc., has been damaged or destroyed during the construction of the work. The whole exercise should be completed in a year. Now, this is fixed by the division bench.
Division bench is saying adequate.
No.
compensation.
Kindly come to page 65.
Well,
Admittedly, the damage caused to the land and properties have already been assessed by the SOENS, and this is the amount which is to be done.
Page 664. your lordship.
665.
Even 664.
No, page 665 is relevant.
It is to right to property is no longer a final.
No, admittedly, 665. Admittedly,
Yes.
the damage caused to the lands and properties have already been assessed by conducting a joint survey, and even the quantum of compensation amount to be paid has been determined under the leadership and so and so. As such, the state government shall make the first move by submitting a proposal along with the assessment made to the central government. That is the amount which has been quantified. And on receipt of the same, the latter shall initiate the process for allocation of fund and release the same to the state government, who then shall disburse the same through the deputy commissioner to the genuine landowner so and so when they have been damaged during the construct. The whole exercise to be done in the. And how do you get an interest
No, no,
unless you challenge this order?
No, therefore, your lordship look at the, the volume 3, page 370. But if I can take your lordship to the finding at page 664 also.
That led to this direction.
In the somewhere in mid.
Yes.
It is true.
It
Right.
is true.
It is true, right to property is no longer a fundamental right, but when a property of is affected or damaged while undertaking a public and if such a year is not compensated adequately, the consequence is fine to his livelihood is affected and that would lead to violation here. I think this is too far-fetched. But then anyways, here Supreme Court has on numerous occasions says that Article 300A is not a fundamental right,
Yes, yes.
but it is a human right.
Human
No
right
quarrel, no
demonstration.
quarrel with that proposition. But my question is, when the court says that you assess this amount, the amount has already been assessed, pay within 6 months.
No, that.
How can you now say you did not go against this order?
No, my lord, your lordship, now, can you see at the volume 3, at page 370, when the government started doing this assessment, and they have completed this assessment.
No. You see, this is, yes, it was done earlier. But now you are trying to challenge that compensation.
No, we are not challenging it. With that
Yes.
part is okay.
No, you say you approached in the year 2019 saying that, look here, they have assessed and found out one area 5 crores, other 55 crores and so and so. But they have not made us the payment. And as such, you have filed a PIL. PIL was disposed of in 2023 after 4 years. And the PIL says that this amount which you have been quantified has already been done. And as such, the state should move the center will allocate the fund and the payment will be made by the DC by issuance of notice. So thereafter, if I allow you, means am I not sitting over the judgment of the division bench?
No, my lord, the judgment is that the state authority will make.
I think we need to dismiss it immediately, go to the division bench may notify.
My lord, one thing, my lord, other way, lordship can say another thing.
I
Now,
can't spell it.
supposing this land, they were required to, acquire the land.
Hmm.
In that case, what will happen? I went into interest, I went into solution
No.
on that.
No, they are not acquiring the land.
No, they are not acquiring, they haven't done that.
Therefore, I say, why don't you go to the civil court? The adequate compensation is less, but this is not the case.
For interest, my lord, it is in
The
that.
question of interest does not arise because you should have asked at that time when the PIL was filed
No,
and say,
we have a prayer for interest also. No?
yes, and then wouldn't the adjudicator apply the explanation for that when you make a prayer and the prayer has been rejected, it will be deemed that it has been rejected.
Is there any?
No, when there is no finding, it means that it has been rejected. That is the explanation 4 to section 11.
My disposal, but the concept of adjudicator is not coming here.
Why not? If you had the prayer out there, kindly see one. It is a concept of, and if you see 1986 Supreme Court, it says the concept of constructive adjudicator duly applies. Kindly see this explanation 3.
No, that
4.
expression.
Any matter which, any relief claim in the plaint and which is not expressly granted by the decree shall for the purpose of this section be deemed to have been refused.
No, where is that condition?
So therefore, when you are making a claim and nothing has been mentioned in the decree, it shall be deemed that it has been refused.
No, let me make some further study on that. Let me satisfy your lawsuit.
Not satisfied. Isn't it, Mr. Santa? Shouldn't I dismiss it?
Let me make more understandable. The lawsuit, can you give me another chance? Let's see. This is not a case, my lord,
It is a case because the problem lies out here that you made a mistake. You should have, I think the best way is file an IA that one thing missed out and thereby kindly consider that this assessment was made then. But what the division bench said out here, that paragraph is the main problem. it says that you have already done it under the leadership of the deputy commissioner. Now, therefore, move the central government and then make the payment. Now you are saying that yes, this we sought for this 5 crores and 55, but these were assessed in the year 2015-16. And as these were assessed in 15-16, they should also include further amount, taking into account the value of the land in 2015 or the damage which was in 15 and 16. And what should we have got in the year 2024? The amount is very less. And it should have been then compensated. The adequacy can be either looked into by enhancing the amount or by applying the interest, the adequacy can become this. This is your case.
Let me make some more understanding.
Okay,
No chance.
try your luck. Some other court. Within this next 6 months, you get dismissed. And after 6 months, if I come, this is dismissed. I make it a point. This goes for a 6. And Mr. Santa, you remember what I said? You put this particular thing whenever it happens.
Just I want to alert my knowledge in the sense, this adequate compensation. It can be said that because the court has said adequate compensation and he has sent it to the government for the best of their wisdom, they will decide. Now, is it the best idea of the welfare state to see that the citizens should not be exploited? Because they are poor farmers. And Indian farmers as well, they do not have any other occupation. If once they are uprooted, it is all gone. Now, which the property has been damaged 2012. Now, that value they are not getting this amount of compensation. To some extent, it can be compensated by virtue of interest.
Have you shown that the assessment was made in the year 2016?
2016, they have started the assessment
Assessment.
completed,
That is why the assessment was completed in 2016.
but they did not give it.
They didn't make the payment. So therefore, but the problem with you, which is for the single bench to pass an order becomes very difficult because of that finding. If I direct you that you should pay additionally this, means I'm touching on the compensation, which is directed to be paid by them. Unless you say very well that you may get one order to that effect that, look here, this is the amount which is there. The amount is there, we have got, this is the admitted amount. But as actually the damage was this. You can very well ascertain the damage either by way of enhancing the compensation or by applying the interest. This is one of the methods by which you enhance the compensation. Why is the interest paid? I read one of the judgment, I think 87 or 88. Interest is paid to compensate the loss.
Exactly, our endeavor is that.
That is what your interest is paid. But the problem is, you have a big problem with the judgment. Because now you are challenging after taking the amount, you are now challenging the amount of the quantum. The quantum was done taking into account what has happened in 2012.
Yes.
And the direction came in the year 2023. So now kindly enhance our amount. An enhancement can happen either by way of additional taking into account some parameter, but one of the parameters is by way of applying interest on the amount which was done in the year 2016. This is your case.
Yes.
But problem lies there in that different bench. You are now trying to unsettle what has been held by division. So only thing was you should have got it dismissed and then approach the division bench. And the division bench can then look into and say that yes, this is only has to be said that only it is in respect, but he can ask for some other amounts. That the division bench can say. I can't say it. Problem lies there.
Let's say big improvement.
I can't. Anyways, at the request of Mr. S. Dr., the learned senior counsel, assisted by Mr. Asham and the learned counsel, appearing on behalf of the petitioners, the matter stands adjourned to be listed again on. When can you get? Bill? 50? 21st of April 2026. Chalo.
Okay.
For admission, item number 12.
Yes, what is this?
May I please conclude? Lordship, this matter is pertaining to the appointment on commissioner ground, Lordship.
Hmm.
Your Lordship, the petitioner submitted an RTI. And if the Lordship may kindly come to
Then
page
you
27,
submit when did you submit your application?
application 20/09/2024,
Then?
2024, Lordship.
Then what is your standing now? What is the stand, Mr. Sandam? Nobody is there. What is your stand out here? No instructions?
I'm not agree.
Okay.
Your Lordship, the petitioner is as number 5, Lordship.
Then,
Under the list of commissioner.
very well, you will get it when you get it. But now nobody is there for the state government. Yes, Mr. Langkumar.
Concern is not disposed of your Lordship.
What is your name? The petitioner's name?
Not that one, Lordship.
Huh? Where? In which page?
The petitioner name is page 27, Lordship. Page 27. Under one division, Lordship.
Very well. Number? 5.
Serial number 6, Lordship. 6.
Six.
6, Lordship.
Okay. So you filed the application on 11/2.
I filed my application on 20/09/2024, which was forwarded on 20/09/2024, which was forwarded on
Okay.
06.
Mr. Langkumar, just give him the copy of the petition. Mr. Langkumar, taking into account the addendum to the office memorandum dated 17/3/2015
Yes, Lordship.
and that is 9/4/2019, kindly see at page 27. You see, the petitioner is number 6.
Yes.
His father's date is on 16/9/2024.
Yes, Lordship.
Petitioner has to go to number 5,
Yes.
isn't it?
Yes, Lordship.
Because this person cannot go up the petitioner. Anyways, I think as the Mr. Langkumar, you obtained your instructions on this aspect.
Lordship.
You are challenging this. Therefore,
No, Lordship.
you should be considered as per number 5.
Lordship.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. M. Langkumar appears on behalf of the state respondents. The petitioner herein has filed the instant writ petition, being aggrieved by the inaction on the part of the respondent authorities in granting the petitioner appointment in terms with the office memorandum dated 17/3/2015. This court had issued notice on 12/12/2025. However, no instructions have been placed. Be that as it may, in terms with the office memorandum dated 17/3/2025, read with the addendum dated 9/4/2019, isn't it?
Yes, Lordship.
Addendum dated 9/4/2019. It is the policy of the state that, where's the addendum?
Page 11.
Huh?
Page 11.
Addendum dated. Man. That compassionate appointment made to Group C and Group D posts under the scheme shall be strictly in the order of date of death, and first preference shall be given against those who have died earlier and who fulfills all other eligibility criteria. Be that as it may, this court finds it relevant to take note of the information provided to the petitioner by the superintendent of the Director of Health and Family Welfare dated on 22nd of August 2025, wherein the petitioner's name in the district-wise Grade 4 compassionate applications till 2024 has been shown at for the district of Mon has been shown at serial number 6, though the petitioner's father expired on 16/9/2024, whereas the person at serial number 5, father expired on on 24/3/2025. Mr. Elongkumar, the learned counsel appearing on behalf of the respondents, shall obtain the necessary instructions on the next date. List this matter again on 24/2025/26. You could just get this, we can dispose it of.
From the supplementary cost list for admission, item number 21.
What is this?
Your Lordship, this is a land ownership appointment. Petitioners are asking for land ownership appointment. And on the last occasion, this honorable court has directed me to get the instructions from Lordship.
To produce the necessary instruction on what basis it was appointed.
Yes.
What is the instruction?
Your Lordship, with regards to land ownership status, the verification has still been awaited, Your Lordship.
What is the name of the petitioner? Pito Sumi. And who got the post?
Yes, 2/4. Tukuto White City.
Mr. Longpur, you bring it on affidavit. You are also same. You also same like the respondent. You're also nothing out there. And why should we take your matter after 6 years? You have filed after 6 years. A person who has now been confirmed, why should we say that not everything?
What's your place?
Huh?
My stand is also that one, because now I'm also over age. I can age 42 this year. He was aware of this odd appointment approval and appointment in the year 2008, and he has challenged it in the year 2020.
But maybe you also means I would have understood you have any other right. That is any other right is different. You are not claiming on the basis of land ownership. That has not been done.
Received to verify.
In pursuance to the directions passed by this court, dated 23/3/2026, Mr. M. Longthomal, appearing on behalf of the state respondents, have placed certain documents wherein due reasons have been provided as to why the private respondent have been chosen to be appointed as an MTS, medical attendant. It is the opinion of this court that the said aspect be brought on record by way of an affidavit so that the petitioner would have an opportunity to rebut to to have an opportunity to file any reply. Considering the above, list this matter on 4th of May 2026. Affidavit be filed on or before 27th of April 2026. You file affidavit. And affidavits be filed by both the state respondents and the private respondent on or before 27th of April 2026. The maintainability of the writ petition on the ground of delay and laches is kept open.
For admission, item number 22.
What is this, madam?
This, my lordship, I pray for this honorable court's intervention because in the previous order that was passed by this honorable court, where my lord will recalling that the petitioner was terminated from service, and I challenge his termination on the
Affidavits filed.
punishment.
Affidavits filed.
Yes, everything is done. Respondent also have filed.
I passed the stay order, na?
Yes, lordship.
It is continuing.
Here, the only issue here is the.
You filed the additional affidavit.
Oh, of course, finished. I have read.
Okay, let us fix it for hearing. Hearing?
Even I'm not the concerned counsel. Even I was going to ask for adjournment on behalf of Tipapo March.
AIME.
Tipapo, he was here in the morning, but
He was here.
yes, this is a medical emergency he had to
Sure.
do.
Here it seems that a lot of councils have medical emergencies. Because that, I think there needs to be a change in for the ground of adjournment, medical emergency.
My case is only based on 2015 1 GAT. Only that paragraph 9 which is.
Anyways, it is seen that the pleadings are complete. Accordingly, this court admits the instant writ petition and directs the writ petition to be listed for hearing on 5/5/2026. Interim orders passed earlier shall continue till the disposal of the writ petition.
For orders, item number 13.
Lordship, on previous submission, I have read this court to file an IA for implement of necessary for the lordship. So I filed the IF for implement this morning only.
Okay, it has been submitted on behalf of the learned counsel for the petitioner that the interlocutory application has been filed for arraying necessary parties. So list this writ petition along with the interlocutory application on 7th of April 2026.
For orders, item number 14.
My lord, my lordship, the notice about the weapon number one is awaited, we have taken steps about the exception number one by way of registered AD as well as industry. We are taking initiation to serve the copy of all the respondent by through the SP work through. And then the notice is awaited.
Notice is awaited.
So we are here to receive the original copy.
Upon respond number,
One.
state of Nagaland.
Yes, no, the progress group.
Okay, he is working somewhere.
She's in Longside village. It's a remote village in a village in Gauhati district. So
You have not been able to serve.
yeah, so we are trying to serve her by way of justice personally.
Now, service is deemed to be complete. That's the office note.
In that case, my lord,
Taking into account that the service is complete, list this matter again on 6th of April.
For orders, item number 15.
May I please, Your Lordship?
Yeah.
Probably service is not completed probably in this case, my lord. To the respond number 4. And on the other hand, I would like to seek permission from this honorable court to file additional affidavit, my lord, to bring on record some relevant documents and facts connected with this case, my lord.
Okay.
In the
It is seen from the office note dated 5/3/2026 that the service upon the respondent number 4 is not complete. The counsel appearing on behalf of the petitioner submits that he would like to file an additional affidavit. Taking into account the above, list this matter upon service upon the respondent number 4 being complete. Because the liberty is given to the petitioner to file additional affidavit, if so advised.
any date, my lord, if possible.
I cannot. Service is not complete upon respond number 4.
My lord, difficulties is there, my lord. We are outside from council, my lord. We are sometimes unable to go through the daily post list. So, if no date not fixed, my lord, sometime it may be, my lord.
I cannot do so, Mr. Counsel. I understand.
My lord. My lord.
For orders,
I'm obliged.
item number 16.
Unless you say that you are going to take service upon by Dusty upon the respond number 4, then I can fix it. Otherwise, I can't. Sorry.
My lord. My lord.
Yes, what is this?
My petition, using the search made by my lord custom authority on the ground that at the time of my lord seizure, my lord, goods taken was suspected to be of foreign origin, my lordship. Page 50, my lord, can we see?
Why the matter has come for orders?
My lord, for consideration of entering prayer, your lordship.
You've not got it.
There is an order, my lord.
What is this?
Page 50, my lord, can you see inventory? And my detailed description of goods, 480 bags. Erica nuts, supari, suspected to be of foreign origin. My first ground is, my lord, the plea conditions as contemplated under section 110 of Custom Acts that reason to believe at the time of my lord the seizure has not been fulfilled, my lord.
Why?
Because, my lord, here you also will see, I will come, my lord. The authority are saying that on the basis of suspicion they have seized, my lord. There is no material, my lord, on what basis seizure was made. Only on the basis of suspicion I will place my lord decisions also for having the reason to believe, my lord. Materials are required to be taken into consideration for coming to the conclusion that yes, there is a reason to believe. Moreover, my lord, subsequently what they have done when we applied for provisional release, my lord, page 56, my lord, they have changed their ground also. Now they are saying page 56.
Yes.
It is referred to as so the matter has been examined with reference to the provisions of the Custom Act under section so and CGST Act. It is observed that at the time of interception, the vehicle was transporting goods without generation of the valid e-way bill. As per section 68 of the CGST Act, read with rule so and so, generation of an e-way bill is mandatory for movement of goods, irrespective of the nature of supply, even for self-transportation between own godowns to the following documents are required. My submission before your lordship is, my lord, if there is a violation of GST, my lord,
Custom has no business.
my
Lordship, it is a case of seizure made under customs, Lordship. If I may take your Lordship to my affidavit in opposition at para number 4. My lord. The present petition is premature, misconceived, and not maintainable in law. The seizure has been effected under section 110 of the Customs Act 1963, and investigation is presently ongoing involving determination of origin, ownership, and legality of the good. Now, my lord, when the vehicle in question was intercepted in a
How many months do you require?
Lordship, the investigation.
How many months to require to ascertain? We have already 4 months over.
Lordship.
How long?
Lordship, but the investigation.
No, understood, but how long?
No, Lordship, I'm coming to
You then you said it, okay, given an undertaking that the cost of AI you will give it, no problem, you keep it. Given undertaking that in the circumstance the materials get spoiled, you will give it to them.
No, Lordship, but
No. You go ahead, have it. I'm not saying anything. But if the Erica nut gets spoiled, given undertaking in the court that we are going to reimburse them for the cost.
But
that's all.
But my
The amount is not much. 2 crores 25.
Lordship.
22. Given undertaking.
Lordship, but the petitioner is not cooperating with the department to conduct the investigation, Lordship.
Where are the seized Erica nuts?
Lordship.
Where are the seized Erica nuts?
Lordship, yes.
You need to just find it out from some test or other that whether it is of foreign origin or not. How do you find out?
But Lordship,
No, my concern is, Mr. Devnath, how do you find out
Lordship,
that it is foreign origin, not foreign origin? Erica nut. Let us also be more, let us know. How do you find out that this Erica nut is from Burma? This Erica nut is from, where did they catch
Indonesia.
it? Indonesia is too far. Indonesian, it will come from Burma. Indonesia, you have to cross no Erica nut will come by that way. Indonesia, my goodness. Indonesia, you cross the entire ocean and then bring it to somewhere. Nobody would bring. It will be somewhere in Myanmar. Myanmar, not Indonesia. Tomorrow you may say Australia. The best part about Indonesia is, it's in southern hemisphere, not in northern hemisphere. So they will bring it to the northern hemisphere to sell Erica nuts in Gauhati. Anyways, how do you assert it? Whether it is foreign or not? Give us that. When you are suspecting it, you have to. And otherwise, it is for the GST authorities to look into. If there is no transit challan or not, it is not within the ambit of customs.
No, I understand, Lordship, it is not within the ambit of custom. But there are instances which has formed the reason to believe that it is of foreign origin.
So therefore, how long? How long?
Lordship, but the
Means-
petitioner has to cooperate with the department for
He
the.
will come up and say that, here, look here, I purchased it from Burma.
No, but the
What do
origin
you
and the
want?
ownership, Lordship.
No, no, he, petitioner claims the ownership by filing the incident with petition.
No, he has now claimed the ownership, Lordship.
Ah.
But when the goods were seized in a smuggling prone region, there was no documents with the driver of the vehicle.
Now he has.
Now he
But
has.
at that time also, except e-way bill, everything was there. I have placed that matter can be seen.
No, it's okay. Now you provide those papers.
This is a writ petition. I have an experience in providing it.
Do I look like the
My registration.
Mr. Goyal, do I look like the custom officer? Then
Will provide.
provide it to them and they will release it.
Lordship may, if my lord may kindly peruse the delivery note at the delivery note, page 47, page 47. Lordship.
Yes.
Yes. Next 2, Lordship.
Page
Internal page number 47, next chapter 2, Lordship. Of their writ petition, Lordship.
47. 47 is some other thing. No? This is some 47.
The delivery notice.
Yes.
Lordship. May kindly note that on the right hand side, bottom part, Lordship, it is for Sarvadeva Vanijya Private Limited without signature.
Okay.
The second part is the terms of delivery in the middle part of the delivery note, Lordship. There is dispatch. It says that dispatch from Abdullahpur, pin so and so, 493 bags, gross weight.
Where?
Lordship, in the middle
Dispatch
part of-
from Abdullahpur.
Lordship.
Where is Abdullahpur?
Somewhere in Hailagandi, Lordship.
Oh, this is come from
Yes,
there.
yes.
And
Hailagandi-
why is Nagaland here? Where it is taken to which
Lordship,
plant?
The seizure was made by the custom Nagaland, Dimapur.
Why? Dimapur comes into the scene. It went to where?
Lordship,
It is
was-
coming from Hailagandi
Hailagandi.
to where?
From Hailagandi, it is coming to Gauhati. They are claiming
So
that
how does Hailagandi and Dimapur has in it?
no, it has been seized in Lamding region. Lamding Hailagandi road region, which is a transit route
Okay.
for this smuggling.
So it is there.
Yes.
And why it is being moved here?
Lordship, under the information received by the Dimapur customs, it was intercepted.
You have the jurisdiction there.
Lordship,
How?
you have the jurisdiction.
Lamding?
Lamding region, Lordship.
Your jurisdiction is
Lordship.
Lamding also.
No, Lordship.
Very well. Until where?
Till I think it is Jamuna Mukh. From Dimapur to Jamuna Mukh.
This is Dimapur range. Customs.
The customs Dimapur.
Okay.
Lordship, under the reason to believe, because the precondition of section 110 of customs, it says that there has to be reason to believe that the goods.
So you mean to say that if they produce you the proper documents, you'll release it.
Lordship, but they could not produce it.
They'll produce you. You consider and release it.
Lordship, but then
I'm not saying, I'm using the word you consider and release it. This is the interim order I'll pass. I'm not asking you to release it.
Okay.
You consider on the basis of their documents as to whether a case is made out for release or not.
In that eventuality, Lordship, if the petitioner may be asked to cooperate with the department.
That is what I'm asking them, him to submit the documents pertaining to that consignment.
Lordship.
They will consider it.
Lordship.
And thereupon take a decision.
Lordship.
You may release, may not release.
No.
We'll fix the matter again on 27th for further consideration.
Lordship.
This is the best. Heard Mr. A. Goyal, the learned counsel, appearing on behalf of the petitioner. Mr. V. Devnath appears on behalf of the respondent numbers 1 to 6.
Lordship. 1 to 6.
1 to 6. The present writ petition has been filed challenging the seizure / detention of the goods by the respondent number 5 and 6 on 6/11/2025 on the ground that the exercise of jurisdiction by the respondent number on the ground that
My lord, resolution number 6.
on the ground that there was no condition precedent, on the ground of non-satisfaction of the condition precedent to exercise jurisdiction under section 110 of the Customs Act 1962 by the respondent number 6.
5 and 6.
5 and 6. One person has seized it.
My lord.
One person
One
is
person, but he is also, my lord, in the seizure, my lord, during in preparation and boundary or
5 and 6. No, who is to seize it?
superintendent respondent 5 he has seized.
No, I'm not concerned. Who has the power to seize? Is it the superintendent or the assistant one?
Not proper official.
First, it is being submitted that from an inventory of the goods seized, detained, the basis on which the seizure was made was on suspicion, and suspicion cannot be a ground to exercise jurisdiction under section 110 of the Act of 1962. First, the learned counsel for the petitioner further submitted that the basis on which the goods of the petitioner were seized have subsequently changed when the application was filed for provisional release of the goods. Inasmuch as now the respondent number 5 provides the reason that it is in violation to the provisions of the CGST Act and the rules framed therein under, in respect to which the customs authorities have no jurisdiction. Per contra, Mr. V. Devnath, the learned counsel appearing on behalf of the respondent numbers 1 to 6, submits that the respondent authorities are not able to proceed with the investigation on account of the non-cooperation of the petitioner, inasmuch as the documents have not been placed. He further submitted that if proper documents are placed, the respondent authorities are not adverse to releasing the goods upon due satisfaction. Today, the petition is being taken up on the ground for the purpose of consideration of the interim prayer. The interim prayer sought for is for release of the goods which were seized on 6/11/2025. First, taking into account their respective submissions, it is the opinion of this court that the ends of justice would be met if the petitioner is given an opportunity to the respondent, opportunity to submit the detailed documents in respect to the consignment of the goods which were seized on 6/11/2025. And upon satisfaction of the same by the respondent number 5. Satisfaction, and upon satisfaction of the respondent number 5, the goods may be released. Accordingly, this court therefore fixes this matter again for further consideration, for a matter again, the repetition, again on 27/4/2026. In the meantime, the petitioner shall approach the respondent number 5 on 5th of April 2026 and place the necessary documents in respect to the consignment, in respect to the inventory of the goods which were seized on 6/11/2025. The respondent number 5 shall, upon consideration of the said documents, consider as to whether the inventory of the goods which were seized on 6/11/2025 can be released or not. If it is of the opinion, if the respondent number 5 is of the opinion that the goods can be released, the same be released on or before the next date, release forthwith. However, in the circumstance, it is the opinion of the respondent number 5 that the goods cannot be released, a speaking order be passed and the said be placed before this court on the next day.
Goods with vetting, man.
What?
Goods with vetting, but truck is also with vetting.
The vehicle. Goods with the vehicle.
But
Vehicle to no problem.
no problem.
Vehicle, why should I put the goods in the vehicle? You can take it. You want the goods lying on the road.
Boom.
Then
Bye.
what?
Oh, hearing?
No hearing, no hearing.
No hearing.
Matter what?
Complete.